To give folks a lay of the land, so in the US, there are two broad areas of injustices. We've got civil injustices and criminal injustices. On the civil side, there are over 74% of low income households that have faced at least one legal problem in the last year. And civil legal problems range from housing related issues, so think of someone who's running into challenges dealing with their landlord, so tenant rights. It could also be employment discrimination. And then on the criminal justice side, there are a number of issues, but what we're going to be focusing on in this session is related to resentencing or second look case reviews. And so our internal analyses, as well as some recent research studies, show that there are thousands of individuals in California in particular who could be considered for a reduced sentence or a release, but have not been granted so due to a number of institutional, political factors that we are trying to tackle with technology. And so our AI approach, coming to why we're here at FACT, is transparency based. We prioritize interpretability and explainability in our models. And we also are very particular about augmenting our tools with legal expertise and not replacing lawyers in the process. So we're not building some fancy AI bot that's going to replace an attorney and then automatically review a case and then decide whether someone's going to be released or not. This is very much technology that's going to work in tandem with legal expertise. And so instead of going in detail about each of these philosophical ideas and principles, we're just going to show you our tools and really walk through the technology and what we've developed. And then we hope we can bring it all together at the end, and we'll review the principles and try to make sure that we've communicated how we've incorporated these ideas in our work. So with that, I will hand it over to Arman, who is the founder of OpenProBono.
All right. Hey, everybody. I'm Arman, founder of OpenProBono, and I'm going to tell you about our AI approach and goals. Yeah, so here's our problem statement and basically our what we're trying to accomplish. Allow non-technical legal experts to both build and evaluate these legal AI tools tailored to their specific use cases and topics, and really quickly, easily, and accurately. So yeah, here's a broad overview of sort of what I'll go over. So in order to accomplish this, we built this LLM-powered platform using, architecture includes large language models and search tools. These sources, which you see here, are ones that we've done, but really they're completely customizable depending on the user's needs and process. And then lastly, we'll get to the evaluation, which we're just getting started with as we're working with our partners. So yeah, this diagram basically outlines our architecture, our retrieval augmented generation system. We take a pretty standard approach to this if you've seen other retrieval augmented generation systems. But there's some specific things we've added that really make the system customizable, transparent, and well suited for legal research. High level overview, you can see sort of the front end on the left. And the bulk of the system is in that green section. Our databases for the conversations and agents, and the vector database, which is where we store the actual legal information and sources across the top. And then on the bottom, you see our LLM calls, which are mostly via API, but not limited to. It could be local models as well. And you also see LangFuse and Milvus are two tools we use, which are also open source. So basically, everything in here is open source besides, the foundational models that we call over the API, but even those could be if you decide to use an open source model. And then, like the embedding model we use when we embed the sources into the Milvus vector database, and then some external APIs for the tools. So I'm going to dive deeper into. So start with this. Basically, the agent definition is where the users really have the power in customizing. So they, from the system prompt to the exact tools and resources available to the specific model, and we'll see how this affects the downstream portions of the architecture. So basically, the agents can either gather information using static databases, like ones containing case law, regulations, or any documents you decide. But the real interesting part that we've made is this search tools that basically dynamically add to the vector database based on either APIs or content on the web. So when an agent search tool like goes on the web and adds a page, it will basically it helps in basically making sure that we don't have a huge cost in terms of pre-processing all of the documents. So pre-processing all of the documents like we would in a static database. So it really frees up us to create these new models quickly and make use of all of the great content on the web. But we also have a trade-off in terms of the actual processing takes longer, because when you find new results, we have to do all this work in terms of embedding it. So sacrificing that sort of upfront load and putting it during the actual, when the user is interacting with it. So these search tools, these domains are specified by the bot creators. This is done using like prefixes. This is really similar to if you've used Google search and you can filter based off domains. So really this is really powerful for the creators because they have really close control over the sources used when doing retrieval. And it also increases the transparency for the users who may use agents created by others, because they can also see exactly what content the LLM has access to. And it's, make sure it's grounded in actual reliable and accurate sources rather than just any content on the web. So in addition to this filtering based off of that, we have some other stuff in terms of summarizing. So we make sure that whenever you receive a certain part of the larger document, you have some context about what the document is in a whole. We have jurisdiction determination, so we make sure that when we query the vector database, that we don't get semantically similar results that are unrelated because they don't match the jurisdiction. Something in California is completely wrong in Texas, but the semantic search will a lot of times be very similar and have that overlap. And these aspects are not able to be defined from our UI right now, but all of our code is open source, so basically, like we're looking into ways to give this control to the end user as well, but right now it's able to be edited on the back end. So here's some screenshots about our platform. This is basically how the users define the platform. You can see on the right side the actual prefixes for filtering. The core agent configuration on the top left includes the system prompt, and then the chat model configuration, which you can see is OpenAI, but is not limited to that. We also, on our platform up right now, we support OpenAI or Anthropic models. And here's a screenshot of what a conversation looks like. It's a fairly typical chatbot interface, but you see we try and show everything that the model is doing. On the top left, you can see the provider and model, the available tools, and then as you talk, you can see the exact tool it's using, what it queried, what the jurisdiction is, and all the sources that it viewed in crafting its answer on the right side. And this is pretty cool, where we actually, if you click into the sources, you can see the substrings that match. So you can actually click into these substrings on the, like if you click on the blue, it'll just jump you to the part in the blue of the complete document. So you have context of where it grabbed the answer from, and if it's accurately portraying the source that it grabbed it from. So this is our work in progress sort of evaluation. We've had internal evaluations for the agents we've built for a while, but as I'll explain later, we recently started this partnership with the University of Sheffield. And they're working on evaluating some of the agents created on our platform, and we realized it'd be useful for them to have an easy way to run agents against a big set of curated questions, and then and evaluate them, qualitatively, or we really have it. You can add different aspects because all these specific use cases have, different needs for how you evaluate them. So we try and make it as flexible as possible. But we also know that, evaluation of generative AI is hard, and this is just sort of the beginning minimum that we're doing. Especially with the models that are being updated as we're using the API, these results change over time. And then we add the extra, dynamic data being added from the search tools. So it really adds more variables to the mix. But we think that is still a useful tool for the students as they built these models or built these agents. So yeah, so we had this partnership with the University of Sheffield. Basically worked with them over the last semester. We taught them a little bit about AI, about our platform, what use cases and knowledge sources would be useful, and they basically found uses that they thought were interesting. Some of them included like will and trust after death, and like student visas to the UK. They were able to do that, identify good data sources for the agents to cite, and then built the custom agents and evaluated them and compared them to the generic AI tools. And this is actually like a continuation of what they had done the semester before, where they were evaluating, ChatGPT and other generic AI tools, role playing as if people were coming to them with with questions. So yeah, all of them were actually really successful in creating these chatbots. They found it performed much better than the generic tools. They especially liked how it strongly adhered to the specific sources that they defined. And they were able to do it pretty quickly too. That with only a few hours of tinkering with it, they were able to get good results. And even when they tried to do tinkering with the generic AI tools, it still they tried multiple AI tools from Gemini to ChatGPT. But yeah, there's definitely some limitations. A few groups tried use cases which were much too broad in terms of just like generic legal research. So some of them had to focus their use cases on more focused topics. And part of that was also lacking premium database access. We don't have a big proprietary data set of case law or anything. We're just working with what's out there right now, and working on our communication of the technical aspects to really help the students understand what are the pros and cons and how the different variables affect the results. So beyond this university partnership, we're also doing current work with different legal service providers and legal aid. We have a few different pilots now with these focus AI tools. One of them is for legal aid in New York City, basically evidence gathering for defending tenants who are being evicted, from outstanding repairs, complaints, to who owns the deed and are they in good standing. And then another is gathering relevant court rules and procedures in local courts across the U.S. Basically, different counties have lots of local rules and procedures, and self-represented litigants have a hard time, finding what they need. Working with domain experts to build these tools and really expand the evaluations, but most importantly also like assess the impact as we try and implement these processes or these systems into their process as they already work, and making sure that they still have the same effect and quality of work. So yeah, the goals of the partnerships to validate the design and our ability of this customizable LLM agent platform that we built, better translate the technical aspects, expand our evaluation features in conjunction with these domain experts, and yeah, finally, like offer these transparent, open source, reliable tools which create values for our partners, but allow them to more efficiently help the people they already work with every day. So it's really about empowering them to do what they're already doing every day. Yeah, so I mentioned that, at the top, that was our first goal is to do this, but we have a sort of more longer term goal in terms of trying to create a platform that empowers a community of people to collaboratively do this, to actually create, evaluate, and share these models so that they can all learn from each other and improve each other all together. And I think this is really important in terms of identifying bias and other errors, because we know that there will be basically, it's never going to be perfect. So we think it's important that we think this is really important in terms of identifying that. And yeah, now let me hand it over to Redo.
Okay, all right. So Redo.io is a legal tech company. Like I shared earlier, we were incubated at LexLab, which is a Justice Tech Accelerator program at UC Law San Francisco, which is where I met Arman. We were both in the program and we both were incubated at the same time. We also work very closely with the Three Strikes Project at Stanford Law, which is a law clinic that represents third strikers in the criminal law system in California. And so to give folks a lay of the land, to get started, there have been a number of reform measures that were passed in the state over the last 10 to 15 years, starting with Prop 36, which was essentially meant to correct egregious sentences for nonviolent offenders who were on their so-called third strike. And so what the law did was said if an individual has 3 felony offenses and their last offense is nonviolent and non-serious, then they should not be sentenced to life. And so it eliminated life sentences for nonviolent offenders. There are also other laws that were passed. So Prop 36 in 2014 reduced any felony offenses for low-level crimes like a robbery or a theft to misdemeanors. And then more recently, in the last 6 to 8 years, there have been this new wave of discretionary measures. So starting with prosecutor-initiated resentencing, which essentially gave district attorneys the authority to look back at any case that had been prosecuted by their county, regardless of whether it met these conditions of a 25-year to life sentence and whether it was just, robbery related or a low-level property crime. But really look back at any case and say, this sentence does not seem to be in the interest of public safety or justice today. So it's a very arbitrary, open-ended requirement. And then we've also got other reform measures like the Racial Justice Act, which is incredibly novel in its own ways because it enabled the use of statistical evidence in the law, which has not been done previously. But as with all good things, the implementation lags behind. And so Colleen Chen, she's a law professor at UC Berkeley, and she has this great paper that talks about the second chance gap. And she defines it fairly broadly. So think of any reform measure. It could be in the space of expungement, record clearance, or the work that we're doing, which is resentencing. And so there's an opportunity, right, which she estimates to be in the millions for the entire country. But the implementation is actually only affecting a very small subset of that population. And so for our use case, we've categorized the limitations broadly in terms of the access to right tools and technology, right? One aspect of it is access, but also the existence of the right data and the right tools. And the second is institutional and political factors. So like I shared earlier, a number of these measures are discretionary in nature, which means that there is no legal obligation on a DA or a judge or even a public defender to implement these measures. And so with Prop 36 and Prop 47, they were mandatory in nature. So it meant that if somebody had, say, one of these low-level property crimes or low-level theft offenses, they had to have their offenses reduced to misdemeanors. So they were mandatory in nature. It didn't rely on whether the political incentives were actually in line with criminal justice reform, but it just had to be done by the nature of the law. But something like the Racial Justice Act, for instance, there is no obligation on part of these judges or other political actors. So one of the big challenges is this discretionary nature of these statutes. So how do you incentivize actors to actually leverage the power that they've been granted? And then, of course, we have barriers related to funding, other kinds of political challenges. So criminal justice reform in California and, in general in the US and in other countries tends to be kind of a leftist political stance. And so in counties or jurisdictions that are more right-leaning or more conservative, it's sort of harder to make a case for it. So we obviously don't have time to go through every single one of these barriers, but one of the barriers that stands out to me the most is funding for public defense. And so if you look at the US overall, this is an estimate from 2022 to 2023 released by the Office of the State Public Defender in California, you see that public defenders are funded a fraction of what DAs and prosecutors are funded. And the difference is more egregious when it comes to federal grants compared to state grants. Another statistic that does not get a lot of attention is the fact that over 25 or 50% of jurisdictions don't have an institutional public defense organization. They contract with private law firms to provide indigent defense. And these contracts are problematic for a number of reasons. One of the challenges is that these are defined as fixed rate contracts. So just right off the bat, you are probably able to tell that a fixed rate contract disincentivizes attorneys from spending all of the time required for effective representation, right? Because essentially what a fixed rate contract says is a private law firm is given, a budget for 2 years. It could be, say, $200,000, for instance, and it's an undefined number of cases. So those cases could be anything from 50, it could be 100, it could be 200, it could be more than that. And so the attorneys in that law firm are incentivized to reduce the number of billable hours per case so that they have greater profits at the end of their 2-year contract. So this is, obviously extremely problematic. The other aspect of fixed rate contracts that don't incentivize effective representation is when it comes to post-conviction work. So the post-conviction component is not clearly defined in these contracts. Typically, private law firms are only given cases to represent if they're referred to them by the court, right? But let's say you have an organization like ours that does these analyses independently, and we identify individuals who we think have received egregious sentencing, we actually don't have anyone to send these lists to. So 25 out of 58 counties, we don't have an institutional public defense organization that can put their hand up and say, okay, we will do the work to talk to the DA, we will do the work to talk to the judge, and try to get this person relief. And the third component is the personal relationship. So most public defenders, they have somewhat of a rapport with their judge or with their DA. They have an understanding of how friendly they are, how unfriendly they are, what kind of language is going to be effective with them. And so that whole interpersonal component is not available when we're talking about private contracts or fixed rate contracts in particular. And so then I want to focus a little bit on the Racial Justice Act. So one of the landmark laws in criminal justice reform is the RJA, and it has not reached the full potential for a number of reasons. But before we get into the challenges, I want to actually talk about the law itself. And so what the law says is that so the 4 motions. You've got the A1 and A2 motions, which essentially provide relief for anyone who might have faced discrimination in trial related to the language of a prosecutor or the language of a police officer. So say, for instance, there was a DA or a police officer that made a very racist remark in trial. The defendant has the ability to retroactively request that a judge reconsider their case because there was discrimination involved. The statistics-related statutes are A3 and A4 motions, which put the burden of proof onto the defendant and the public defender who's representing them to show that similarly situated individuals who belong to other ethnic groups were not charged or prosecuted or sentenced to the same sentence length or the same offense codes as the said individual. So this could be a difference in the raw length of the sentence. So we're talking about, say, a white defendant and a black defendant. One of them had the exact same circumstances. So we're talking about, say, an armed robbery. The black defendant also had an armed robbery and similar past convictions for, say, other minor petty theft offenses. Maybe this individual had a history of homelessness. But let's say the black individual was sentenced to 15 to 20 years as opposed to the white individual who was sentenced to just 10 or 15 years. I might have. Say one of them was sentenced to 10 and the other was sentenced to 15. And so that's an obvious difference statistically in terms of their sentence lengths. You can also show this difference in terms of, say, enhancement. So this is for folks who are familiar with the criminal legal system. Gang enhancements is another area that has proven to be plagued with racial discrimination. It's typically Black and Hispanic individuals who get additional enhancements on top of their offenses for having some sort of gang affiliation. And so what the law requires broadly is to show that there's a causal relationship between race and ethnicity and disparate sentencing. And it must be done for individuals who are similarly situated. One of the challenges with the Racial Justice Act is that the court doesn't exactly tell PDs how to do these analyses. And so that's where organizations like ours try to come in and give public defenders the tools to try to study the population and identify these kinds of racial injustices. And so I want to give folks an example of the degree of the problem. So if we look at just folks in California prisons who are serving time for what's called the non-non-non, so these are non-serious, non-violent, non-sexual offenses, so typically very low-level crimes, we're talking about around 500 people. These folks have been sentenced to over 20 years, have served at least half of that sentence, and their incarceration costs the state roughly $50 million a year. This is a very simple extrapolation, just using the cost of incarceration per year per the Legislative Analyst Office's estimates, and then timesing that by the number of years that's left on their sentence. So this is a very simple example, but think about just removing one of these offense codes from the list of what's deemed to be a non-violent or non-serious crime. So here we're talking about, say, a robbery that doesn't involve any type of weapon or any type of harm against a person. So there was no fighting involved. But if you remove one of those offense codes and then you allow, say, an attempted robbery or an attempted assault, we're now slowly increasing that cohort of eligible individuals. And so this is, a very baseline, simple cohort to start with. And then as and when we modify our criteria, this cohort is going to grow in size. So our solution has three components broadly. The first component is related to open databases. So like I shared at the beginning, we need to have the right data in order to do these evaluations. Unfortunately, in California, we don't have an open database of prison sentences. So there's no place that you can go to right now besides our tool and ask how many people are serving time for a petty theft, which is a question that some of you may actually be wondering right now from this presentation. How many individuals actually fall into this category, right? How many people are serving time for a robbery for, say, 10 plus years or 15 plus years? We don't have these kind of exploratory tools right now. And so the first piece of the puzzle that we've tried to fix is creating open, accessible data sets that are free, that anyone from a journalist, an attorney, a DA can open up, download, play around, and figure out where there are opportunities for resentencing. And the second pillar is building out these tools. So we have a number of analytics tools, which I'll share, that help process the data that we've made publicly available. And the third is more in-depth analytics that are not just exploratory, but actually make recommendations and identify eligibility for resentencing. We do this in two ways. One is simple rules-based systems. So we're talking about simple criteria and filters that allow you to eliminate certain cases, that allow you to pass certain cases. And then we have some more complex models that allow you to rank individuals based on their suitability. This is an example of our open data set. So we've got over 95,000 individuals, so 95,000 records. We have everything from their ethnicity to their primary controlling offense to other current commitments, prior commitments. We can also see whether they're a third striker or not. So this is where you can actually find opportunities for resentencing. Folks who should have been resentenced under Prop 36, which was passed in 2012, but were not granted relief for a number of reasons. So our data is free, it's open source. We have 95,000 records. We have 3 tables on demographics, the current commitments and the prior commitments. The current commitments and the prior sentences also include all of the enhancements. In total, it comes to around 75 variables. We try to request this data from CDCR, which is the California Department of Corrections and Rehabilitation, every 6 to 8 months. Unfortunately, they're not very good at honoring public records requests, as other folks have pointed out in this conference. So we have 2 data sets right now. One is as of December 2023, and the most recent one is March of 2025. In terms of privacy, we de-identify all of the data sets, although they were released to us under the public records law, which means that we don't have to. We can just release these data sets as is. But we made a decision internally to hash all of these IDs so that we are protecting individual privacy. So we have single IDs that then map these records across all of the 3 data sets. And then we ask attorneys who are using our tool to make a request to us stating the purpose of their usage, and then we provide the raw IDs, names, and case numbers if their mission aligns with our mission for criminal justice reform. So that's how we also control what the tool is being used for, and so it's not being misused by bad faith actors to make non-scientific claims about the population. So some of the limitations with the data set, if you recall on the RJA, the A3 motion essentially allowed for reconsideration on the basis of not just disparate sentencing, but also disparities in arrest and charging. So what this means is, say you've got a prosecutor who is charging 2 individuals differently, but they're both ultimately sentenced to the same offense code and the same sentence length. You can also claim RJA relief if the DA prosecuted you for a more egregious offense or sentence length compared to someone who is not Black or not Hispanic. This data is very difficult to obtain because it is not centrally located. This information is in the possession of each individual district attorney office. And so for folks who are not, again, from the US or California, each DA it's a county by county or jurisdiction by jurisdiction setup. And so we've got 58 counties, so 58 district attorneys' offices. This data is also very difficult to access under the California Public Records Law because DAs want to protect their data as much as possible, and a lot of the information is identification information, so there are arguments around personal privacy, HIPAA, and whatnot. And so the only ways that PDs have been able to access this information is through a discovery motion. So typically when you are requesting the court for additional information, you have to have what's called a prima facie showing. So at the beginning of your argument, you essentially show to the court and the judge that there is a substantial reason to believe that sentencing is not fair. And so then you get the DA to turn over additional records and information about the individual. And so that's one of the only ways that folks have been able to get data on arrest and charging. Another limitation with our data set is that it does not include juvenile offenders. Well, actually, the juvenile offenders are included, but they're not explicitly identified. So this makes it difficult to actually evaluate their cases if we're talking about data acquired under the CPRA. If it's not public records data, so if we have a direct relationship with the county or with an organization like the Three Strikes Project, we get far more detailed, comprehensive information because it's not released under the public records law. So similar to juvenile identification, we also don't get information on rehabilitation or other risk assessment scores and education milestones. Excuse me. Okay, so some low-hanging fruit. We built out a simple dashboard. This is to help attorneys who are not very comfortable using complicated technical tools and just want something very easy to understand and help them with a prima facie showing. So this is extremely beneficial for folks who just need to get the DA to turn over data that can help them do more complex analyses, right? So if you can just show, for instance, in this first graph, in the entire population, you have Black and Hispanic individuals who are overrepresented. And so that itself could be beneficial to get additional data from the DA side. And then if you have details on the case that you're representing and you know what their controlling offenses are, what their prior convictions are, you can then set these filters and then get even more demographic disparities. And then our AI tool helps attorneys query this data set. So the first offering is a very simple sort of custom query where an attorney can say, find me everyone who is serving time for a theft-related offense. They pass that query, and then we return all of the responsive records. So the way it works is there's a natural language query, the LLM interprets it, finds all of the values and conditions based on these logical statements. That is translated into SQL and Python code, and then we extract those relevant records and return them to the user. So this is an example of how our tool could be used in a prima facie showing. So let's say you're an attorney, you're representing someone who is a Black individual who's served over 10 years for a series of robberies that were committed across a 10-year period. So the first thing you might do is try to find individuals who are what's called similarly situated, right? So if you recall the RJA slide, we need to compare individuals who have similar circumstances in terms of their prior and current commits, right? So the first thing that you would do is say, let me find everybody in the prison population who is serving time for the same offense, which is a robbery, but they also have a similar profile of past and current convictions. And so then you might want to examine these offenses in depth, right, and try to understand the circumstances of the case. And then lastly, you want to show that there is a statistical relationship between race and disparate sentencing. And that's actually quite obvious by the chart on the right, because you can see that Black individuals are overrepresented for robbery and theft-related offenses in relation to the entire population. But something like this may not be sufficient. You would have to show specifically for that individual's controlling offense plus exactly similar prior and current commits, not just a broad robbery or theft. But this is an example of how one might do that analysis. We tested our model using around 150 prompts. So we had someone that we recruited on Upwork to just pass a number of prompts that fall into these categories. So we're looking at prompts that could have, high risk language. So something like, are Black individuals just more violent in nature? And so how do we target that kind of use of our tool? There could also be queries that are related to that have multiple components, so not just 2 or 3 logical statements, but are a combination. We've seen some issues with the use of ands and ors and commas. That's not always clearly interpreted by the LLM. So is it a union or is it an intersection? Is it a mix of both? So that's where we see some issues. And so we've essentially iterated our own prompt to try to address these limitations. And so far I've been talking about some of these simple rules-based systems to help do a first pass analysis of the population, but we also offer more complex metrics to be able to compare individuals. So let's say you have these 2 candidates, individual A and individual B. It might be very obvious just at first glance that the person A is a better candidate for resentencing, right? They're much older. They only have nonviolent offenses. They've been incarcerated for 25 plus years, and they've also shown a commitment to rehabilitation by attaining an associate's degree. And they don't have any rules violations when they were in prison, right? So rules violations could be anything from using drugs to getting into a fight with another person. And then the person on the right, individual B, is serving time primarily for violent convictions, right? So this is sort of an obvious distinction between the two. But how do we formalize this? So how do we actually show computationally that individual A is a better candidate or a stronger candidate for resentencing? So we do that through a number of metrics. I'll also share a paper that we're working on towards the end. And so if you're interested in how these calculations have been set up, I encourage you to read that. So these are some measures of the frequency of offending, the age of the individual relative to the entire prison population, the severity of their offenses. So did they go from being a non-violent offender to a violent offender or the other way? So what is the positive or negative slope of their convictions? Their commitment to education and rehabilitation. So did they, attain an associate's degree? Did they attain a master's degree? What about their behavior? Did they actually commit to enrolling in any kind of substance abuse program or other sorts of treatments and therapies to help with, say, anger management or other criminal behavior? So one way that this ranking can be used is by say, just asking an attorney to weight themselves what parameters they think are most relevant to their county and their jurisdiction, right? So if, say, there is an awareness of a judge who is very easily convinced by individuals who have committed to education, which is the case in several counties. So PDs and DAs who've worked in these jurisdictions for a very long time know that there are certain judges that are very friendly to folks who have, say, attained a master's degree. And so you might want to then weight these education-related parameters more heavily and then weight the offense-related parameters on the lower end of the spectrum. And then we also have a machine learning based model. So as opposed to an attorney applying weights themselves, we can also train a model that learns the most optimal weights. And so imagine a simple regression where you've got a vector of weights, you have a vector of all of your metrics and parameters, and you want to optimize those weights for past suitability decisions. And so we're building out a data set right now where we're evaluating candidates that have been successfully resentenced in the past, and we're giving those, giving attorneys some time to give us feedback. And so this will be what our optimization problem looks like. And so in addition to just showing that an individual is a strong candidate for resentencing or not in a binary fashion, we're adding another layer where we're showing the degree to which they are suitable or the degree to which they're likely to be successful. And so one of the I think aspects of our work that tries to tackle this issue of ethics in criminal justice reform technology is how we use different tools in combination. So instead of just building out, say, a standard prediction model where you plug in a bunch of data, you're learning these weights, and then making a prediction based on a prediction for, say, recidivism, what we're trying to do is put things in layers, right? So we're giving a lot of leeway to attorneys to decide how they think these evaluations should be done. So these are a few examples. So you can have an attorney use, say, a rules-based model in combination with a scoring system, and that scoring system can be generated through custom weights where they themselves decide which parameters or metrics are more important than others. There are other ways in which you can combine these tools. So for instance, you can do a rules-based filtration and then look at the weights that were generated from our model and prioritize or rank cases that way. These are just a few examples. It could also be the case that an attorney just doesn't want to have any kind of algorithmic decisions whatsoever, and they just want to use a rules-based system. So if they want to do that, then they're able to use the tool in that way as well. And so some of the ethical concerns, there are known limitations with these sorts of vector representations. You cannot possibly describe an individual in a arithmetic formula. There's so much more to their story, to their journey in prison, to what brings them to where they are today. There are also challenges with age and disability. So a lot of folks who've been in and out of prison for, say, 20, 25 years, they might be extremely disconnected from technology, and so they're struggling to, say, enroll in a distance learning course because they're unable to actually talk to staff and have someone help them navigate these new tablets and laptops that they're given to try to get ahead. So going back to what I shared earlier, we do not have a black box model. That has been a topic of conversation at FAC over the last several years. If you recall, the COMPASS model was challenged by ProPublica, and then there were several researchers that pointed out issues with the ProPublica analysis. So the COMPASS model is a black box pretrial risk assessment. There are also other recidivism risk assessments that are out there that are being used that are proprietary in nature. But our tool is not. It is fully open source. And then our tool is also not predictive, right? So we're not actually trying to predict what is the probability that somebody is going to be successfully resentenced. We're trying to offer another characteristic or another dimension that can help evaluate whether an individual is suitable or is a strong candidate for resentencing, which is an argument that will play a role in this person's resentencing trial. And so to date, we've been able to recommend over 400 cases, primarily to counties that have institutional PD offices. And then the other cases that we have identified that we haven't found representation for yet, we refer them to clinics like the UC Berkeley Criminal Law and Justice Center. Folks are aware of Chesa Boudin. He's the executive director there. We also recommend some of these cases to the Three Strikes Project if they are third strikers. We've reviewed around 80,000 cases, which is over 90% of the prison population, and then we've released all 95,000 records that were provided to us under the CPRA. And if you're curious, feel free to read our paper, and you are all welcome to reach out if you have any questions, and Arman and I are also more than happy to take questions now.
Question, but I would say this is awesome.
Yes.
It's been one of the best things that I've seen in this conference.
Yeah, thank you so much. Yeah, this is meant to be a tutorial, so if folks have questions about the technical details or any other questions about the Open Pro Bono tool, feel free to let us know. We can also go back through the slide deck. Yeah, yes.
I do have a question about the OpenProBono tool. I just want to make sure I understand the target users for that. And then I also have a question about the other as well. Is the idea to be anyone, or is it really for legal audience?
So it's definitely for legal audiences, but we're sort of building the tool as flexible as possible so that, people across jurisdictions from, working with people in the UK with the University of Sheffield, but also legal aid in the US. So building technology for the legal use case, but, keeping it as flexible and sort of abstract as possible as we're doing it. And yeah, the intended users are definitely like legal professionals and legal aid but at the same time, it's not like a general legal tool. It's meant to sort of be used so they can implement, specific use cases and specific topics rather than just some, big algorithm that does everything. And yeah.
It's a question, but it's maybe I missed it during the presentation, but has your work led to anyone being released as part of this yet, or?
So these resentencing processes take a very long time. We have received a lot of positive feedback from the PDs that we've recommended cases to. In some instances, they tell us that few folks on the list are already their cases are in progress, and so that's very.
Thanks to you, or in general?
In general, so it might have been referred through another channel, or it could have been referred to by the court. So it's also possible for an incarcerated person themselves to file a habeas petition and say they believe they're being wrongfully incarcerated, and so then they get representation from basically a court-appointed lawyer, which will be somebody who is indigent defense attorney. But for us, that's positive because it means that our criteria are matching what the PDs likely to consider.
Second question. So, I mean, this would also be a very interesting tool for journalists.
Uh-huh.
Have you considered, collaborating with them to? I mean, they have other means.
Yeah.
In a sense, but I mean.
Yeah, so we haven't done any outreach to PDs as of yet, but they are a category of individuals who can use our tool that we've listed on our website. It is open source, so you're able to access our tool right now and pass a query and find individuals who you think are interesting for reconsideration. But that is something that we could potentially do, so do more work engaging directly with news organizations and investigative journalists. I think that's one of the big benefits of the raw data set, which is something that there are tons of organizations that have published aggregate statistics. So the Public Policy Institute of California, for instance, they have these really nice pie charts that they publish every couple of years that talks about the distribution of the population. CDCR also releases these aggregate statistics, but nobody's released a granular database where you can look individual sentence by sentence and say, what are the circumstances of this person's case?
Very inspiring.
Yes.
Thank you so much for the talk. I was wondering about the how was it called, like the racial justice law.
Uh-huh.
Like if you prove that there is some statistical difference, let's say between populations, who could be resentenced? Like is the whole group potentially able to be resentenced, or is it only a subpopulation of the bias?
Yeah, that's a great question, because let's say you have an individual who was successfully resentenced, somebody in the scenario that I described earlier, a Black individual who is serving 10 plus years for a robbery or theft related offense or series of offenses, and say you show that there is a strong reason to believe that their sentence is egregious because of racial discrimination, then you can look for other individuals who fall into that cohort, which is why our vector similarity measures are helpful, because all you would have to do is look at individuals who have the same profile, right? The same profile of past convictions, the same commitment to rehabilitation, and then you can just run a bunch of cosine similarity evaluations and then figure out a cloud of individuals who surround that case that was successfully resentenced. Yeah.
Just out of interest, did you also find, for example, individuals which are quite similar in this vector embedding space but have completely different sentencings? So from the number of years they were sentenced?
So you mean individuals who have similar profiles in terms of their prior and current convictions and rehabilitation, but have different sentence lengths? So that would be a Racial Justice Act adjacent evaluation, right? So you would be looking at individuals who have very similar profiles, but have different sentence lengths. And if you're able to find candidates like that, that would be a very strong argument for resentencing.
Okay. Interesting. And you're embedding all of the information in those vector embeddings, or just a part of it?
Everything that we have access to. So let me go back. Yeah, this is what our embedding looks like right now. But this can also be modified. So if we're able to get more data from CDCR, so for instance, we don't get COMPASS scores right now. COMPASS is another metric to evaluate recidivism and risk. And so if we got that data and an attorney was very interested in adding that to the model, then we would just add an extra metric here and have their COMPASS scores relative to the population. We could also, if we were able to get information about individuals who committed their offense when they were a juvenile, then we could add a juvenile offender metric as well. Yeah, so we are constrained by the data that CDCR is willing to give us. Because we're getting this information under the Public Records Act, they don't provide details about all the details about milestones that have been achieved, education related or mental health related, because it could be a violation of health privacy laws. But when we have direct relationships with counties and academic folks in, say, places like the Three Strikes Project or the Criminal Justice and Law Center at UC Berkeley, they get access to data from CDCR. So when there's a data sharing agreement in place, we're able to access the entire profile of the individual. But the caveat there is that it still doesn't include arrests and charges. That is still in the possession of the district attorneys. Any other questions?
Maybe I have another one. In the case of, like, when you use the weights to score the metrics and which ones are more important, I mean, this is more like to make, let's say, to be the devil's advocate. If you, for example, would choose education to be more important, would you kind of bias towards people who are, I mean, you're kind of biasing towards people that have like less education. Do you see this as a potential problem or not?
Yeah, definitely. I think people who have more education in prison also tend to be individuals who are more comfortable with these systems, navigating them in the first place, right? Which means that before their incarceration, they were probably exposed to some formal higher education, which might not be the case for somebody who offended as a juvenile and has been in prison for the majority of their adult life, right? So you are sort of implicitly introducing more bias. The way we try to tackle that is through the plug and play model. So what you could do then is have an attorney generate a list of individuals based on some very simple rules, so through a process of elimination, and then you rank individuals based on their suitability. So you don't technically eliminate anyone from that list, but you're just prioritizing certain candidates that you think are likely to be successful. Another aspect of the Racial Justice Act is it doesn't just try to protect or advocate for individuals who belong to vulnerable groups based on race and ethnicity, but also country of origin. So think of individuals who are, say, incarcerated in ICE, for instance, ICE detention. If they came here as a minor, came to the US as a minor, they don't speak English, they're not going to be able to access a distance learning associate's degree program or a bachelor's degree program in prison just because they don't speak the language, right? And most of these programs don't offer multilingual, they're not offered as multilingual programs.
I guess that then like another question to Arman. Would you see some like I am not a law expert at all, but would you see some differences in the implementation if you like implement it in a state where you have like a civil law? Like coming from Italy, I was wondering about that.
Yeah, I mean, I think the thing is that we're basically trying to build whatever the specific partner needs. So like, I guess you mean like civil law, like case law, or what? Sorry if I.
Like the difference between is it like common law and civil law? Like that you have like a kind of more rule-based approach, and not like board cases.
Yeah, yeah. Honestly, that's like basing on case law is harder, definitely. Like the common law is easier, but we're not really like we had some like opinion search tools that we were using. I mentioned Court Listener early on, which is like a big database of cases in the US. But really like the sort of the use cases which are in the scope of our thing are usually much more focused and defined than like, something which is very broad like that. But it's definitely like it's not impossible. Like our platform is sort of so flexible that, it could be done, but it's probably not going to be not really what it's exactly built for, I think we're good then. Yeah. Thank you all for coming.